appeal in the matter of Mostyn House Estate Management Company Limited and Youde and others.
Yes, Mr. Allison.
My lord, my ladies, I appear for the appellant together with my old friend Miss Sage.
Yes.
So that's behind me. My old friend Miss Lena Matson
Yes.
appears for the respondent. I start with an apology in the sense that I need to check that we all have the right documents.
Well, it's only an apology if we haven't.
Yes, well,
it's a check, first of all.
it's a check first. You should have, I hope, 3 bundles: an authorities bundle, the core bundle, and a supplementary bundle. There was a change to the form of the supplementary bundle, and it's a slimmer one that you should now have. It looks like...
I've been working on the PDF, and I've certainly got those. This physical thing I've got is the supplementary.
Yes.
I'm sure we've all 3 had, either electronically or physically, those bundles.
Yes, but if I can check, because it transpired that there were certain pages missing of the document at tab 6, and copies, an amended tab 6 was sent through certainly in hard copy, and one can check by looking and see if there is a page 48A.
Right.
If there is not...
No. In the hard copy, I haven't got a 48A.
Well, lady, in that case, may I hand up an amended
Nor have I.
tab 6?
Nor have I.
Yeah. Well, they were, to be fair, sent in together. So.
You knew it was going to be an apology, didn't you?
Well, I feared. There were updated skeleton arguments sent last week.
Yes.
Being the core bundle, those were somewhat further in advance, so hopefully you do have those. Those are simply to update the references to the current form of supplementary bundle. If it transpires I'm referring to incorrect references, I'll hand up amended skeleton. I think that will be a problem.
Thank you. After the apology, a compliment. We're extremely pleased to have received both the skeleton arguments from both sides. This is not easy to pick your way through these various provisions, and both of you have done your best, or all 3 of you have done your best to help us with that, and we're very grateful to you.
I'm grateful. Unless it would assist, I don't propose to open at length, but I do want to sort of set out a few core components just to orientate ourselves on development and to explain where the submissions are going. You'll have seen the judgment of His Honour Judge Crawson at page 82 in the core bundle. It's a lengthy decision that helpfully sets out an awful lot of the background which is not in dispute before you. And you'll have seen there's 45 flats and 40 freehold units.
45 flats and 43 freehold units.
40 freehold units, so a total of 85. The 45 leases are in common form, the 40 freehold transfers are in common form, and of note is that one of the 40 freehold properties is one of the listed properties that will be
Jarrah House.
Jarrah House. But that transfer is in the same form. And the setup is there are 3 different management companies: the appellants, which is the estates management company, freehold management company, FMC, leasehold management company, LMC. And that necessarily, unfortunately, is a recipe for dispute, or at the very least friction. In this case, before you concerns the right of the appellant to maintain the school building, but one can well imagine there are other things bubbling under the surface. Just by way of orientation, if we turn to the supplementary bundle, page 57, the blue line on page 57 shows the extent of the development. Of course, predating its development. Yes. And you can see marked on there, on the left-hand side of the page, if you're looking at it the right way up, the chapel, and you can see marked there Mostyn House School. If you then look at page 56, the page before it, the areas coloured in orange, I believe they're meant to be red, but they've now become orange over the passage of time, are the broadly the listed buildings. So the small orange square in the middle of the sea of blue is Jarrah House.
Right.
The chapel, you can see, is sitting on its own, slightly disconnected from the largest block of orange, in the same position as the chapel was marked on page 57. And the rest of the orange, broadly, is the two school buildings plus a little bit of extra land.
Yes.
Or the two halves of the school building, I should say. And to further identify where the school buildings are, because that's, of course, what we're concerned with, if one turns to page 158,
Yes.
the area outlined in blue is one half of the school buildings. And leases of flats within that blue area, call that the estate. I'll take you to that in due course. On page 163, one can compare and contrast. On page 163, you'll see another blue line, which is the other part of the school building, and flats with leases in that part, call that the estate.
Thank you, that's helpful.
Now this appeal is, of course, not about whether the leasehold management company or the freehold management company can themselves do and recover the cost of certain works. It's solely about whether the estate management company can. And I freely accept that on the construction the appellant puts on the document in question, there's a degree of overlap in responsibility. Given the, it might be said, unsatisfactory way in which the documents have come to be drawn and entered into, that's an unavoidable conclusion, I say, however you construe the documents. And I'll take you to the examples of that. It might be said it would have been preferable for there to be a single management company. That's what was envisaged by the Section 106 agreement we'll come to, so as to avoid that overlap of responsibilities. And the overlap of responsibilities point was considered by the Supreme Court in the context of a statutory scheme called the Right to Manage scheme, and they found there, well, actually that's wholly unsatisfactory for Parliament to have intended in the context of a statutory scheme that you have an overlapping management responsibility. It's common sense. But the documents say what they say. We've got to give effect to what the documents say. Yes, common sense might come into it, but we can't override the words used without very clear reason to do so. So we are where we are. We have this significant dispute. The most pressing part of that relates to the upkeep of listed buildings, and particularly this schoolhouse. And you'll have seen, and I'm not turning now in the core bundle to page 14, the grounds of appeal. Permission was granted on two grounds. Resolution of the first ground, resolution of the second ground turns in part upon the answer to the first ground. So I will address you on both alternatives. And the permission decision, you may well have seen, it's at page 80, if not.
Yes. I think we've all three seen.
Yeah. Lord Justice Youde, he noted, I think I'm paraphrasing correctly, ground one was more obviously correct than ground two, and ground two was a point of construction that was not entirely straightforward, and I accept that. That's why we're here.
Yes, if your suggestion is that he thought both were obviously correct, but one was more obviously correct, then that may be over-optimistic in
No.
interpretation, but we're not going to construe that as well.
No, I accept that. I go so far as to say the answer to ground 1 is clear, even if the answer to ground 2 requires rather more work. But we do have to remember we're only concerned with the estate management company's rights and obligations, not those of the other companies. So we've got to give effect to the words used in the freehold transfer. We're solely concerned with the freehold transfer in light of the relevant factual matrix, and that's going to include planning documents which lead to a Section 106 agreement as originally drawn. It was subsequently varied, but the version that you have in the supplementary bundle is the version we all agree was the document in existence at the relevant time, and in fact the subsequent ones don't change the material provisions anyway. We have the Articles of Association for the estate management company. All the management companies have the same Articles of Association. They're set out in the judge's decision as far as their material. They probably don't take this question that far, I think both parties would say. But either the relevant matrix of fact doesn't include the terms of the leases at all, on the basis none had been entered into at the point when the earliest freehold transfer was entered into. That's my primary case. Or the relevant factual matrix does include the terms of the leases, but on the basis of the cherry tree case, which I'll come to, given the freehold transfers are registered instruments, no third-party purchaser could be guaranteed to have seen them. The role of the lease in construing the freehold transfer should be very limited. So the distinction is it might be admissible, but that doesn't mean we give it any weight. Once we've resolved those issues, there's the additional question of what to do in the event the appeal succeeds. You'll have seen the respondent in the respondent's notice says that in any event the appeal should fail on the basis that declaratory relief is inappropriate. And I say broadly, A, it should be remitted back to the trial judge because it's all quite fact-specific. The judge heard all the evidence and is best placed once the construction point is dealt with to make a decision on that. But I also say in any event, the objections of the respondent were considered by the trial judge who gave an indication as to his impression. That's paragraph 89 of the judgment. And then in any event, I have my arguments as set out in the skeleton argument as to the objections and say they're in no way fatal. So if I can turn to focus on ground 1. The key principles of contractual interpretation are agreed between the parties. I don't propose to go through the well-known authorities in any length. They're also set out in the judge's decision, and they're emphasised in my skeleton argument at paragraph 9 onwards. And that's at page 27 in the core bundle. Starting with Arnold and Britton and the usual authorities, if I can put it that way. By way of summary, we're trying to identify what the contract means, not what the parties intended to agree. And we're going to do that first and foremost in almost every case by looking at the language of the provision in question, because parties have a choice about what words they use. I accept we're then going to have to think about commercial common sense. Post Arnold and Britton, commercial common sense is not going to be used to override the clear words of the contract. It's going to be relevant to the extent of how matters would have been perceived by reasonable people in the position of the parties at the date the freehold transfer was entered into. Not with the benefit of hindsight. So if the natural language, when we read it, turns out, as this case demonstrates, it might be said by the respondents to be bad for one of the parties, that's not a reason to depart from that natural language. We're not trying to work out what they should have agreed. Obviously, it might be said, well, they should have agreed something a bit clearer. We've got to construe them in light of the relevant factual matrix. This is the Manai point at paragraph 12 in my skeleton argument over the page, what's described as the objective contextual scene. That's going to include all those documents I listed a moment ago. And then we've got to consider the nature of the document. And this is the cherry tree point. There's a distinction between an ordinary commercial contract and a registrable document. The broad point being a more restrictive approach should be taken to a registrable instrument because third parties might need to rely on their terms. They might not have reference to the extraneous material. So the first overarching point is the terms of the leases can't be relevant to construing the freehold transfers because none of them have been granted when the first freehold transfer was entered into. A document that doesn't exist can't be relevant background. So if one turns in the core bundle to page 110, this is in the judgment. And I'm looking at paragraphs 69 and 70.
Yes.
Paragraph 69 to the second half, I do not consider that knowledge of the relevant provisions of the leases can properly be said only to have been reasonably available to the developer and or the company and FMC and not to the freehold owners. I say that's not a safe conclusion for him to come to. And paragraph 70 sets out...
Because they did not exist at that time. That's the point.
Yes. Well, didn't exist at the time that the first freehold transfer was entered into.
And you say that's the time because you can't have the transfers which were all on one model, meaning something different depending on when they are executed.
Lady, yes.
Before and after a lease.
Yes.
Ms. Batson makes the point, I think, that any reasonable conveyancer with due diligence would have been able to find at least the draft leases. What do you say to that?
What I say to that is that can't be the answer because the answer to how you construe this document can't turn on whether or not there's a cooperative answer to that request. And we have to remember it's not just that the original purchaser could have exercised control over the developer because they were seeking to buy.
Yeah.
Somebody could have purchased the first freehold property and the next day sold it on to somebody else. Well, how does that purchaser
There's no nexus there.
There's no nexus. And so it's got to mean the same thing in all circumstances. And I'll take you to a passage in Cherry Tree in a moment that highlights that point. Just at the top of page 111, little one, the first point the judge relies on is to say, well, the leasehold properties and freehold properties were being developed as part of the same development, agreed, and were sold off contemporaneously, one with the other. They were marketed contemporaneously, one assumes. I don't think there's any evidence on it, but I doubt. It would be odd if they weren't. But that's not the same as being sold off contemporaneously. And that conclusion, I mean, we know they were sold over a period of months, slightly over a year, in fact. And if one looks, just turning back quickly to page 90, paragraph 25,
Yes, there's quite a gap.
there's quite a gap, and that's the leases. So the earliest lease is 16th October 2014. And then sales of freehold properties, you'll see over the page, there's a transfer from May 2014, months earlier. Perhaps unsurprising, but I mean, to an extent, the sales, and you see this in the planning documents, the sales of the freehold side were required to subsidise the cost of putting the school building into a suitable state and converting it. One half of the development turned on the other.
Yeah.
The reason they got planning permission to do the works of the listed the reason they got the planning permission to do the freehold, build on the school fields and lose the school fields and generally lose open space is because the trade-off was preservation of the listed building.
Right.
We can come to the document where that's shown. So it's unsurprising that different bits were finished at different points, sort of inevitable on any development. The fundamental point is freehold transfer comes first. That's a finding of the judge. The finding of the judge is not they were all sold off on the same day. So paragraph 71 is wrong in my submission.
70 little one. Yeah.
70 little one, yes. Yeah, and I'm back on page 111 now, and I'm turning to little 2. The next bit of the reason is to say, well, the provisions of the transfer specifically relate to the leases. We'll come to look at the terms of the freehold transfer in a bit. I'd rather not jump around too much, but suffice to say for now, there is no definition of lease in the freehold transfer. There's no reference to a standard form of lease or any particular provision within a lease. The provisions of the transfer only link to the lease by the definition of retained parts. And that definition, just for your reference, is the supplementary bundle, page 110. But I will take you to it in some detail in a moment. The next bit of reasoning on page 111 is relates to the fact that the freehold transfer contains obligations relating to the whole of the development rather than just the estate. Well, that's undoubtedly correct, but that's the very point we say shows that the clear intention was that the services would relate to the leasehold as well as the freehold areas.
And where is that on page 111?
This is little b.
Yep, thank you.
And then turning down to 70 sub 4, little 4, over on page 112, and concludes, I consider the leases and terms thereof a property to be regarded as part of the background knowledge which would have been available to the parties, including the transferees, and says there is no reason to suppose that it would not have been available for the assistance of a diligent conveyancer. The point my lord was making. But there's no evidential basis for that assumption. There's nothing to suggest that, in fact, they were made available, that there was a sales pack or anything such as this, or even as to when, on what date, a draft lease was agreed.
And the concept of the diligent conveyancer is one that is developed in the law reports. But if there are 40 freehold properties, there might be 40 separate conveyancers acting for each of the purchases.
Yes.
So they've all got to be, or most of them have got to be diligent to have this idea that a diligent conveyancer would function in this way.
Yes, I mean, different people might get different answers. You'd hope not. As I say, the greater difficulty is what happens with a subsequent purchaser. Particularly if that's at a point when no lease had yet come to be registered, which came to happen some months later. And then at 70 small 5, he says, well, the leases are not private documents in the context of the cherry tree case because the leases would have been public because they're registered at the land registry. Well, yes, once they're granted, they're registered. But there was no publicly registered lease when the earliest freehold transfers were entered into. The leases were completed later, and registration will take effect in whatever
Even
time
later.
that registry are managing it at that point in time. And the meaning of the freehold transfer can't change depending on the time at which you seek to construe it. It has a single meaning. So that's our short point. That's our main point, is there's a timing issue with permitting the lease to affect how we construe the freehold transfer.
Well, your fundamental point is they weren't created or registered at the relevant time, and then other problems flow from it. Is that a reasonable way to put it?
Yes. So if they didn't exist, how can they be relevant background? My fallback to that is then to go on to this cherry tree point, which I think was probably the principal way in which the appeal was initially advanced by my predecessor as counsel. And I want to turn to that quickly. If we can turn to the authorities bundle on this, this is probably the only authority I'm going to take you through in any detail, or at least that I'm planning to. Cherry tree is a decision of this court.
Tab 6.
Tab 6, my lord. Just summarising the facts very quickly, the defendant, Landmain, had charged its land to a finance company, and on the same day as the charge was executed, this was a charge in the standard land registry form of charge, the defendant also entered into a written facility agreement, and the terms of the written facility agreement extended the statutory power of sale so that it would become exercisable immediately upon the execution of the charge. And what happened is, on the standard form charge, the parties erroneously left blank the panel on the form that provides details of the sums to be paid, and there's no reference to the written facility agreement on the face of the charge. Charge is registered. Of course, the written facility agreement wasn't referenced in the charge and isn't registered. Finance company serves notice on the defendant saying that the sums secured by facility agreements would become immediately due and payable. They sell the land to the claimant, and the claimant goes to register the property, and the defendant objects. And the defendant's objections say, well, the property can only have been sold by the lender if a default had occurred, essentially going behind the terms of the facility agreement. So the claimant applies for summary judgment that it can be registered as proprietor on the basis the finance company and the defendant must have intended that the power of sale would arise immediately and without the need for default. And we had to construe the charge as if the parties had not made the mistake of failing to complete box 5. Claimant succeeds, defendant appeals, and this court allows the appeal. Lady Just Sarden gives a dissenting judgment. The majority hold that the charge should not be treated as including the extended power of sale. And that's because the extended power of sale was included in the facility agreement, which was not referenced in the charge. So that's the broad outline of that case. As I say, Lady Just Sarden sets out her dissenting judgment first, contains some useful summary of the overarching principles and features of the land registration system. I don't propose to take you through those now. I'm taking you to Lord Justice Lewison's decision, which starts at paragraph 90, and it's paragraph 99 I want to take you to first. Page 51, in the red numbers at the bottom right. And this is the point. Whatever the document means, it's always meant what it means. It can't mean one thing in one context and one thing in another. It can't turn on what the person reading it does or does not know. Lord Justice Lewison then runs through the special nature of registrable instruments, and at paragraph 104, this is over the page, he accepts, essentially on the basis of prior authority, albeit that prior authority predated the Land Registration Act 2002, accepts the principle that the court need not shut its eyes to the existence of the facility letter, or in our case, the lease. And I put that as a caveat, assuming a lease existed at all. So the court need not shut its eyes to it on the basis of admissible evidence, but that still leaves the question, what do you do with the admissible evidence? How much weight do you give it when construing a public document? It then works through the features of the land registration system and its operation, the fact that parties will only be able to obtain documents that the land registry hold. And his conclusion is at paragraph 123, and I invite you to read, and my apologies, it's a slightly long passage, 123 to 125. My Lord, that last sentence of paragraph 125 is the answer to the question you posed earlier in my submission. If third parties might need to rely on the terms of the instrument under consideration without access to that extraneous material, it's no good saying, well, a diligent conveyancer could have asked the developer or the vendor on a subsequent sale for a copy of the
On that view,
draft
it's irrelevant.
sample
That
lease.
might have happened.
Yeah, because it's might. What if the developer said no? What if the vendor couldn't produce one? They might then need to rely on the freehold transfer without reference to the lease. And if the answer is just to say in these cases, well, the conveyancer could have asked for it, that would have been an answer in Cherry Tree, wouldn't it? Conveyancer acting for Cherry Tree could have said, oh, we've noticed box 5 is blank. That's unusual. Are there any collateral documents related to the charge we should be aware of? They had a clue in box 5 that there might be something else, just as it might be said, well, there's a clue in the freehold transfer because there's reference to a lease that there might be another document to look at. The last passage I want to take you through in this is paragraphs 129 to 130.
So that, if I'm following, that ties in with the first section of Lord Justice Lewison's judgment you took us to, that a document can't mean one thing to one set of eyes and another to another. And if it's a public document, it must mean the same thing to anybody who reads it. And anybody who reads it will not include someone who's got a diligent conveyancer, who's directly interested in the purchase of a property, etc.,
Yeah.
etc. It means what
It
it
can't
says.
mean different things.
Yes, it means what it says, full stop.
Yes. So, on whatever basis ground one is decided, whether it's on the basis that it simply didn't exist, or whether it's on the basis that, well, something probably did exist, even if it was a draft form of lease, I say either way, it doesn't help us with the answer to ground two. Now, I also say, even if it was admissible, it doesn't take matters that far. But the key distinction is going to be, if you don't know what the terms of the lease are, you don't know about the leasehold management company, and you don't know precisely how the leaseholders are paying for the upkeep of their own building, it doesn't make a difference to knowing what the definition of retained parts means, and that's common ground between the parties.
Sorry, it doesn't.
Doesn't make a difference to what the meaning of retained parts is, so far as it's relevant to this appeal. When we run through the documents, I'll explain that point. So, to be clear, I don't say ground two fails if ground one fails, because we still can construe the documents in light of the leases in the way I suggest, but I do say we shouldn't pursue that course because the leases are not admissible. Unless there's any question on ground one, I was going to move to ground two.
Thank you very much.
Thank you. So this is the question of how to properly construe the freehold transfers, and we've talked about the relevant background. And you'll have seen the judgment sets out some of the background in detail. I think it's really important in this case that I do take you to the underlying documents. I'm afraid this may take a little bit of time because I want to highlight all the relevant features. I'm turning to the supplementary bundle. And if we take them in date order, I'm starting at tab 16, page 171. This is the local authority planning report that underpins the decision of the same date to grant permission, planning permission. You see the date's the 11th of July.
And is this admissible?
This is a public document and it predates the freehold transfer. I don't think there's a dispute about its admissibility. The question of weight might be a different point. But, and the recommendation you can see on that page is to approve. I just want to highlight a few paragraphs in here. Over the page 172, at the top, paragraph 1.1, the application site lies entirely within the Parkgate Conservation Area, comprised of disused public school and its grounds. The majority of the buildings were designated as listed buildings in June 2011. You can see they're grade 2 listed, and the chapel is grade 2 star listed, and we have the reference to Jarrah House. The fact that the pre-existing, or some of the pre-existing buildings were listed is a key feature in the decision to grant planning, and we can see that being carried through at numerous places throughout. So I'm turning first to page 174. Paragraph 5.2, English heritage. Their concern is principally as to the chapel. And they say, the fourth line down, the public benefit of securing a long-term use for the school is considerable, and English heritage is therefore now satisfied the application can be recommended for approval from an historic environment perspective. If the application is approved, it will be important to manage the scheme with appropriate conditions and agreements. emphasis on management. You can see below that the Victorian Society, no objection, subject to a £100,000 fund to maintain the chapel. Details of how the service charge will contribute to the chapel's maintenance. At 179, this relates to a viability assessment. So the developer puts in an appraisal showing the viability, taking into account the costs and the values of the expected properties. And you can see fourth line down, these have been tested by the council's own chartered surveyor, whose findings are set out above. The conclusion is that enabling development of 39 new build houses is required to raise enough revenue to cross-fund the conversion of the existing main school building into 48 apartments, provide a 100k dowry, pay a 100k commuted sum towards the alternative playing pitch provision, and to provide a profit for the developer, sufficient to make it marginally worthwhile to carry out the development. This was the point about the freehold houses being integral. They facilitate and vice versa. Over the page at 6.7, reference to extensive problems and being expensive to fix. In order to generate the necessary funds, it's proposed that the new housing be built in the school grounds. And then on 181, small b, the creation of a management company for the whole site would avoid fragmentation and secure the future of the chapel, which would otherwise be very difficult to protect. It's the significant benefits of the whole site being developed by a single developer. Except the emphasis there is on the future of the chapel as opposed to the listed buildings more generally. And then you can see at C, just underneath, fourth line down, it will be vital to ensure that both the ongoing management of and necessary repair works to the listed buildings are carried out as proposed in a timely manner at appropriate stages in the development process. This will be secured by a Section 106 agreement. And then lastly, on page 188, you can see the recommendation. With conditions 3 and 5 being the only ones of any relevance. That document underpins the planning decision and is the background to the Section 106 agreement you find at tab 6. It's now 3 months down the line, 4th of October 2013. This document's important, A, by way of background, but B, because when we come to the freehold transfer, it refers to the obligations of multiple parties to comply with the provisions of Section 106 agreement. So we've got to work out what that says as well.
Excuse me, Mr. Allison, and excuse me, my lord and my lady. I am extremely sorry, but I have to rise for a few moments.
Very good. We'll rise for a few moments.
Spare skeleton argument.
Yeah,
You haven't.
we do.
Lunchtime.
No,
We have some additional questions. Do you think we're okay? We were wondering. I won't trouble them. Their lordships might require additional questions. If you leave it. Thank you. Thank you.
It should be all right. It's looking promising.
funds effect. Firstly, to 16th of October. The Factual house to 30th of October. This is the least predated. You can see the Jarrah house is also in the official copy.
No, but the transfer to Jane Milligan is May 2014.
Yeah, other transfers are produced on the 30th of October 14. So
Yeah.
that 16th of October lease, you said he found that the freehold transfer was before the lease. Well,
Yeah, because there's a freehold transfer of May 2014. The transfer to Jane Milligan is dated May 2014. And other transfers have been produced.
okay, got you. Lovely. Thank you.
Answers and the judge's answer. Yeah. Depends what view they take of it. Yeah, it sort of makes sense because they finished building first. Because they did phase 20, it's in 106, isn't it? They did 20. And they have to do the school stuff. They're not allowed to complete some of the others until they. That's their the local authority's security. I mean, you should be still saying there would have been a draft form of lease floating around. People could have got hold of it.
Yeah.
No, yeah, exactly.
At least
Same
not.
point.
At least not.
Yeah, well, that's what you say the judges make. Make a decision. They think it's horrible. We do to construe it. Because you know see. The same proportion. That's how they do it.
Internal part of this depends upon the construction of the internal
Yeah. But it's the overlap where they've fallen into error. Objection to multiple management companies for saying just don't make them all responsible for the same thing. And theoretically, you could maintain the school. You the freehold. Why would you?
Mr. Aston, I apologise for the interruption. Do carry on.
Yes, I was
You
going
need
for
to
the
go
pause.
back just a word or two.
Yes.
We turned to the Section 106 agreement. I don't think we got as far as opening it, as it were.
We hasn't.
Any
No.
provision.
I was just turning to the 106 agreement. I'm on page 48 now, tab 6 of the supplementary bundle.
Yes.
In the usual way with the Section 106 agreement, it's a contract between the council, because they're seeking to secure planning conditions. You can see number 2, the owner. So they're the people who owned the site prior to development, the developer who was about to buy it, and a mortgagee. And we have in the preamble, under whereas, I'm looking at D and E, the background is the grant of planning permission that provides for certain works and repairs to be carried out to the listed building on the development site in tandem with the housing development.
And it's a condition of the planning permission that they have to enter into an agreement
Yes.
of this sort.
Yes. And you can see at E, again, the reference to the listed building and being in a serious state of disrepair. And then we need to turn to the interpretation provisions. Chapel means exactly what you think it does. We've already seen that on the plan. Chapel Maintenance Fund is that sum of £100,000 to be used solely for the maintenance of the chapel. That's a sum that was transferred to the appellant.
And the chapel, this is purely out of interest, it just sits as a chapel now. Is it used as a church? Is it not converted into a dwelling?
It's not converted into a dwelling. No.
Yes,
It's common parts.
yes,
It's not
it's
an
just
offensive
there.
way of describing
Yeah.
a chapel.
Yes.
It's part of the common parts of the estate. Whether it's still used,
No,
don't know.
there we are.
One imagines not. It's immediately next door to the flats.
Yes. Who knows?
Development site. You may recall that first plan I took you to, the blue line that showed the outskirts of the entire development. That's that plan. Again, the page reference is 57. So that's the meaning of development site. And then jump down to listed building. This is important. Listed building, even though it sounds like one building, is the schoolhouse with which we're concerned in this appeal, the chapel and Jarrah House. And you'll recall those were the areas coloured. It says red there, but they are now orange on page 56.
And we'll see in a later document that the schoolhouse, in fact, has been divided into 2 separate estates for the purposes of the...
yes, for management purposes.
management, yes.
Yes. Management company, this is 3 definitions down, means the company,
The company.
singular, set up in accordance with clause 5.5 of this agreement to manage the buildings in the listed building and the new build dwellings.
To manage the dwellings in the listed building.
So that will be the flats and Jarrah House, and the new build dwellings being the other 39 freehold houses. So one company managing leasehold and freehold parts. Just underneath that, you see the definition of new builds means the bit coloured blue. That was that plan I took you to earlier. It had the orange and blue. You had the sea of blue with Jarrah House in the middle. That's the new build. Just stepping back, the way the freehold management company that my own friend represents would like matters to work is you have the sea of blue managed as its own estate. The leasehold half underneath is entirely managed on its own basis, and they all collectively deal with the chapel via the estate management company. That's how they say things should operate. I'm paraphrasing them as niceties. And one can see that might be, at least on their view, a perfectly sensible way of doing things. But it's not what the documents say, is what I say is the difficulty with it. That might have been a way to do it. But what they're concerned about...
Well, a difficulty is that the people who sat down and drew up this Section 106 agreement we're looking at now didn't have that model in mind. They had a model of one management company.
Yes.
it seems that at a later stage it was decided to develop a more sophisticated model. And
Well,
it's
all
how,
quite
it's
so.
how the wording of this might sit with the wording of
Yes.
that later set of documents.
And that's why I say there's some relevance in terms of contextual background to that planning document, because the focus here is on securing the listed buildings. That's really what the local authority is concerned about.
Yeah.
And they're less concerned with day-to-day how the grass gets mown. I'm just turning over page 49A, clause 2.1, simply confirms that it is a section 106 agreement. For present purposes, the only relevance of that is this agreement continues to be enforceable against successors in title. It operates similar to a restrictive covenant. So the current freehold owners, so the development as a whole is not owned by a single entity now in terms of the freehold interest. There's a company called Gray that owns the freehold interest in the leasehold part, but not including the chapel, and other bits are owned by the management companies. They are all bound, so far as the bits of land they own are concerned, by this section 106 agreement, because it's enforceable against successors. That's the only point of law that's relevant to this being a 106 agreement. If we then turn over to page 50, what clause 3 sets out to do is regulate the way in which the developer built out the scheme. And just by way of example, if you look at 3.3, no more than 3 new build dwellings could be occupied on phase 1, no more than 20 could be commenced until all the phase 1 works have been completed, and then phase 2 works, the listed building must be commenced no more than 1 month, blah, blah. You can work your way through the definitions. The point is they couldn't just sell all the freehold houses and then not carry out the works to the school and the chapel and Jarrah House.
Well, what's the relevance of that sequence?
The relevance of that is that they start off with 3 new build dwellings being occupied. Well, they're not obliged to have 3 new build dwellings occupied, but they've got to get money in as they go along.
It's a point you've made at 2 or 3 stages that they needed to have a seed corn fund which came from selling off the freehold.
Yeah,
freehold. What's the relevance of that for the point that we have to decide in construction?
It explains why we have the freehold transfer coming before the leases.
Right.
It's that background. We then get to the nub of it, which is what you see on page 50A. Covenants by the owner stroke developer, in essence the freehold owner. 5.4, there's an obligation that prior to construction of the last dwelling, or prior to stopping building, the money, the chapel maintenance fund, that's that £100,000 fund, must be paid to the management company. It was paid to the appellant. No dispute about the fact that the appellant is liable for the upkeep of the chapel. At 5.5, the owner covenants to continue the future maintenance and management of the listed building to a good state of repair and to use the chapel maintenance fund for its sole purpose and ensure such future maintenance and management of the listed building. To ensure it, the owner agrees with the council, and then we have a list of things that have been agreed.
Yeah.
We're focused on the listed building. That includes the schoolhouse. 5.5.1 is that you can't dispose of any dwelling until the management company has been established. And at 5.5.1.2, the owner developer shall ensure that the principal objects of the management company will include provisions that the management company shall continue the future management and maintenance of the listed building to a good state of repair. Focus on the listed building. 5.5.2, to ensure the contracts for sale of all dwellings on the development site contain agreements by the purchasers thereof to subscribe for or acquire shares in or become members of the management company. So whether it's a flat or a house, you have to subscribe, you have to be a member of the management company. And at 5.5.3, to ensure that control of the management company shall be transferred to the owners of the dwellings upon completion of the sale of the last dwelling on the development site. So it's all of it, leasehold, freehold. The leasehold management company and the freehold management company don't achieve that. The leasehold management company is only the members of the leasehold parts, and the freehold management company's members are the freeholders. So only the appellant can sit in the position of having complied with the 106 agreement from the developer's point of view. 5.5.4 we need to consider to dispose of each dwelling by either a freehold transfer or the creation of a lease. A standard form of transfer/lease will be used in the sale of each dwelling so that all transfers and leases contain identical provisions in all material respects. Not prescribed, so prescribed form. But what one might take from this is that the purchaser of a freehold property knows there will be a management company covering the whole of the development and responsible for a listed building. Sorry, the listed building, which includes the schoolhouse. That should be clear to the purchaser of a freehold property. And 5.5.5 sets out a requirement that each transfer and lease contains certain provisions, and that includes the purchaser covenants to pay an estate rent charge or a service charge to cover the costs of management and maintenance of the listed buildings. And then lastly, over the page, the reciprocal part of that, 5.5.5.2, the management company will covenant with the owner and the purchaser to continue the future management and maintenance of the listed building to a good state of repair and to use the chapel maintenance fund for its sole purpose. Yeah. So it's trying to ensure a comprehensive scheme where everyone's obliged to everyone else to make sure the listed buildings are kept in a good state of repair. So that's the 106 agreement. And then we come, logically, to the freehold transfer, because that's the next in time. Tab 8. So we've looked at the relevant background. I haven't taken you to the Articles of Association, but I don't think much is added by them. And we work out what this document means. And that's really what we're doing in Ground 2. So page 107, slightly curiously, under the definition of transferor is where we get the definition of the management companies. The transferor we see listed, and then you'll see fourth line down, with the concurrence of Mostyn House Freehold Management Company Limited, their friends, client, or one of them. They're described as the management company. And then Mostyn House Estate Management Company is described as the company, so that's the appellant. So the appellant is the company, FMC is the management company. Then we turn over to page 109.
So I do know this, but I forgot, what's the date of this?
Well, this is a sample, so it just refers to plot QQQ.
The date of January, is that the 106 agreement?
The 106, the 106 agreement is October 2013.
January 14.
January 14 is when the three estate management companies are incorporated on the same day.
That's the point I got in my head.
And then the judge in paragraph 25 refers to a transfer in May 2014. We don't have a list of all the dates.
So within 3 or 4 months of the Section 106 agreement, we've got to this more sophisticated structure with the management
three companies.
The three companies, and then we get to this transfer, obviously, which follows that because the companies have been set up.
Yes.
Yeah.
Yes. Oh, yes. My note quite really points out at the bottom of page 107 that it does say final April 2014.
Thank you. Yeah, well, that makes sense, that sequence, doesn't it?
Yeah.
Yes, thank you.
I'm on page 109 now. We need to work our way through some definitions and then do the usual trick of trying to remember them all when we come to the next bit. So the chapel, we know what the chapel is, but it's on the estate plan. Let's look at the estate plan, it's page 167, tab 14. It doesn't contain any surprises.
No.
And if you turn to page 167, you can see the yellow is the chapel, and you can see a green outline. That is defined as the estate, the freehold half, if we call it that. That's the estate for the purpose of the freehold transfer. You can turn back to page 166 and see an example of a red line around the freehold house. Doesn't tell you anything you don't already know, but looks like a red line around a plot. And then turning back to page 165, that is the development edged blue. That includes the leasehold part. So just turning back to 109. Chapel contribution, we know that's that £100,000 contribution. Communal areas is a potentially important definition, and this is a point of dispute between the parties. Whilst my principal case doesn't rely on definition of communal areas, I do say communal areas additionally assists me, and the definition is any land on the development which serves the dwelling units on the development not included nor intended to be included in the sale of any such dwelling units. And I say that can be read as including the structure and exterior of the school building, because that serves the dwelling units, namely all the leasehold flats, except it may not serve all the dwelling units, but it doesn't say all the dwelling units.
It includes just the phrase, the structure and
exterior.
Of the school.
Of the school. Because that's not included in the sale of any dwelling unit. My learned friend, I think, disagrees with that and says, well, it's a reference to land and one should give it a more sort of colloquial reading as something open as opposed to a structure.
The word areas may suggest that, but on a plan, the walls are part of the area, aren't they? You're looking from the top.
Well, they are, yes. Communal facilities are things like the estate roads, service installations, but the point here is facilities which serve the properties on the development, not the estate, the development. Definition of development and estate, I've shown you those plans. Estate roads is roads on the development. Sorry, roads which serve the development, not roads which serve the estate, roads which serve the development. And then at 11, maintenance contribution variable rent charge, contributions equal to the transferee's proportion of the expenditure described in part 2 of part 15.
No, I'm sorry, I was just looking at something else. You were in a maintenance contribution variable.
Yes.
Yes.
It's a relatively typical service charge provision in that the freehold, the purchaser of the house has to pay a proportion of the expenditure incurred by each of the management companies, and those proportions are worked out in different ways. And you can see that on page 111, the definition of transferee's proportion. And there are, whilst it says firstly and secondly, there are 3 proportions. if one reads the definition, if the expenditure of the freehold management company relates just to the estate, then you pay a proportion that is a floor area apportionment based on the floor area of your property relative to the floor area of all the properties in the estate.
That's the first box.
The first bit.
Firstly, yeah.
Well, it's the first bit of firstly.
First bit of firstly.
The second bit of firstly is if the expenditure relates to the development, it's the proportion that the square footage of the property bears to the total square footage of all the properties in the development. Bear in mind that's expenditure by the freehold management company that can't recover its costs from the leaseholders. It's a slight curiosity, it's a point that will probably be taken against me. Nonetheless, that's what it says.
If it wasn't, it will now.
Possibly so.
How you paid that in.
I mean, the answer in reality is they probably won't do expenditure that relates to the whole of the development because they can't recover the cost and because there's a duplication of responsibility, and that's where I'm coming to in a lot of these points. And then secondly, an equal proportion of the maintenance contribution variable rent charge. That's the charge payable to the appellant, calculated by dividing the expenditure by the total number of properties. So it's a per unit split. So anything that my client spends, it recovers recovers 1/85th of that expenditure from each unit, leasehold or freehold. I just want to take you back to page 110 now for the last definition we need to look at, which is the definition of retained parts. Number 16 in the middle of the page. Those parts of the development, again I emphasise development, it says including the estate, those parts of the development including the estate and all the other things, not included nor intended to be included in this transfer or the transfer of any other part of the development by a transfer in a form similar to this transfer, and or not included nor intended to be included in any demise by a lease of a residential unit on the development. You may recall I said that this is the point, this is the only point, really, where we need to, where the lease is referenced in the freehold transfer. It says a lease. Lease is not defined. There's no reference to standard terms. And we know that, in fact, no lease has been granted. So what one's left with is working out what was intended to be included in any demise under a lease of a residential unit. And it is agreed between the parties by reason of, I suppose apart from anything else, common sense and the invariable practice that when you have a block of flats, the demise is internal only. It does not include the structure and the roof, because otherwise imposing on a ground floor flat the obligation to maintain the foundations at their own expense, or so on and so forth, or a patchwork quilt of bits of brickwork on the outside simply doesn't work. Yeah. So the structure and exterior of the school will not be intended to be included in any demise by a lease of a residential unit. And in my submission, we don't need to look at a lease to know that. It is, in fact, the position in light of the lease, but we don't need the lease. And if one looks at my learned friend's skeleton argument at paragraph 13 sub 2, that's an accepted point between us. It's also going to include, the definition of retained parts will also necessarily include in my submission the communal areas. If you compare and contrast the definition of communal areas at 109 with retained parts at 16, communal areas must be within the retained parts. So if, as you do, you have one management company responsible for the main retained parts, one management company responsible for the communal areas, you necessarily have an overlap of responsibility. and that is unavoidable. Let's turn to page 112 next. These are recitals, so they give us an idea as to what the parties thought they were trying to do, but they're not the operative provisions, so we have to treat them with that caveat. At 2, this is under Part 3 recitals, 2, the transferor wishes to dispose of each of the properties on the estate by means of a form of transfer in substantially the form of this transfer. So again, the point being its standard form. At 4, the management company, Malone Friends client, has agreed to join in this transfer of responsibility for the services, repair, maintenance, insurance and management of the development. Not the estate, the development. And at 5, the company has agreed to join in this transfer of responsibility for services, repair, maintenance, insurance and management of the communal areas, the communal facilities, and the provision of the communal services, and to ensure that the obligations contained in the Section 106 agreement are performed. Not particular obligations, the obligations. Again, overlapping responsibilities baked into the recitals. And we've got to give effect to these words. Page 114, Part 5 is where the rent charges are granted. Nothing turns on that, it's simply to highlight paragraphs 1 and 3 that there is a grant of these rent charges. It's relevant to the declaration in terms of confirming my client has the right to recover the cost, but I don't think there's any dispute between us in terms of the payment mechanism and the grant of the charges per se. At page 115, Part 6, paragraph 1, the freehold owners have a right of way in common with others over and along the estate roads, which you'll recall are across the development as a whole, the communal areas, that's across the development as a whole, drives, paths, entrance hall, passages, stairways.
Sorry, I was diverted on this. Okay. What paragraph are you on now?
My lord, sorry, it's paragraph 1 of part 6 on page 115. There's other examples in there, but I'm just highlighting an example of how the freehold part is not divorced from the leasehold part. That's really the only point I'm making there.
Sorry, if you could repeat that.
The freehold part is not divorced from the leasehold part. They have rights of way over parts of the leasehold area. Roads, the chapel, paths. Page 118 I'm on now. These are covenants by the transferee, by the purchaser of property. And they're covenanting with the developer, the transferor, and with my client and with Malone Friends, freehold management company client. All of whom, you'll see this is in the words in brackets at the top, all of whom are collectively called the covenantees. Management company, company, transferor. And then at 1 and 2, not to make any structural alterations or additions to the property without obtaining planning, not to make any alterations to the exterior or external appearance of the property. The relevance of this is in the context of that Jarrah House point. And then over the page at 120, part 10, positive covenants of the transferee. These are solely with the freehold management company and not with my clients. And at paragraph 3, to keep the property and all additions in good and tenantable repair. important in the context of Jarrah House. At 5, to protect and maintain in a manner befitting the feature, any original feature of the property, whether or not it's listed, and requiring consent from the transferor and the planning authority if any changes are made. And at 8, to permit the covenantees, now that includes my client, at reasonable times wherever possible, on giving reasonable notice to enter the property to examine its state of repair and make good all defects within 2 calendar months after being given notice. So my client has a right to go in common with the freehold company and the freehold and the transferor to check the covenants are being complied with. That's important in the context of Jarrah House as a listed building. Other than that, my client may have less reason to go in on the other freehold properties, but it's relevant to Jarrah House. Paragraph 9 gives the freehold management company, but not the appellant, the right to go in, do works and recharge the cost. That is said to be relevant to the Jarrah House point because only the freehold management company can go in and sort things out, they say, and recover the cost. And I say that's not right because the estate management company is obliged to comply with the 106 agreement and it can recover its costs as a 185th cost via the estate charge. Except it can't directly recover the costs under Clause 9.
And these covenants obviously affect the freehold properties. The issue before us is focused on the Mostyn House School buildings.
Yes.
So what's the relevance of these particular covenants you're taking?
The relevance of these covenants is we say the estate management company is liable to maintain the school because the school is a listed building and the upkeep of the listed buildings is a Section 106 obligation. And one of the points that's taken against me is to say, well, Jarrah House is also a listed building and that's subject to this form of covenant.
Right.
So how was that intended?
Yeah, so although 95% of the freehold properties
we're not
it's
interested
irrelevant.
in. Yes.
What triggered my thought is it's because of the Jarrah House
Yes.
is in this cohort
Yes.
that you're taking us to this.
I think my learned friend will probably expand upon that, but it's her point to take. But I'm trying to, whilst we're in the document, trying to get through all the provisions so we're all familiar with them. And then over on page 123, this is the covenant to pay. So part 2 is an obligation by the purchaser to pay to the freehold management company the service charge, rent charge, to cover the freehold management company's costs. And then at part 3 at the bottom, the covenant to pay my client's maintenance costs. So they're the obligations to pay. They're relevant to part of the declaration, namely that if we spend the money, they're liable to pay. And then we get to the nub of it, which is part 11 onwards. Part 11 is what the freehold management company covenants to do. At paragraph 2, they covenant to keep in good and substantial repair, reinstate, replace, and so forth, the retained parts. You'll recall the retained parts, it is common ground, includes the school building. So in theory, the freehold management company has covenanted to maintain the school building. So have other parties, as we'll come on to see. But that's what the words say. Same goes for the chapel. Chapel's not included in a transfer or a lease. We can reach the same conclusion if we look at paragraph 4, to protect and maintain in the manner befitting the feature any original feature of the development which is within the retained parts. We can also see it in paragraph 5. To keep in good order as the management company may think fit the grounds of the retained parts in accordance with the requirements of the local planning authority and any planning agreement, including but not limited to the section 106 agreement. The grounds of the retained parts includes the communal areas. As we'll see in a minute, the communal areas is something that the estate management company expressly has to deal with. Paragraph 8, I'm now on page 126. The freehold management company covenants to comply with the conditions in section 106 agreements in respect of the development so far as they relate to the retained parts.
No, I'm sorry, I'm lost. I'm on page 126, paragraph 8. This is therefore the management company. Yes, I'm sorry.
Yes, we're still on the freehold management company's obligations.
Yep.
Then turning over page 127, covenants by the company, that's covenants by the appellant. So now we see what my client's obliged to do. And that's, of course, the most important bit for the purposes of this case. So the company covenants are now on page 128. To keep in good and substantial repair, so on and so forth, the communal facilities and communal areas. As I submitted about 10 minutes ago, I say the communal areas covers the structure and exterior of the school building. What is in my submission beyond doubt is this means that given the overlap between communal areas and retained parts, however one reads it, there is baked in duplication of responsibility in this scheme. At 3 is similar to the provision we saw with respect to the management companies. This is protecting the features of the same bits of the development. At 4, specific provision for the chapel. Even though the chapel is part of the retained parts that the freehold management company has covenanted to maintain. And 6 is where I primarily hang my hat in terms of the liability point, to maintain and manage the communal areas and the communal facilities in accordance with the requirements of the Section 106 agreement, and to comply generally with the obligations detailed in the Section 106 agreement, and in particular to use the chapel contribution. The appellant in my submission is quite obviously the management company contemplated as being the company responsible for the listed buildings in the Section 106 agreement, and that is the reason for the wording of paragraph 6. It isn't confined to the communal areas and communal facilities, although, as I say, I do say communal areas would cover it, but it's to comply generally with the obligations in the 106 agreement. There are not that many obligations in there. It's not a lengthy document. One must read it as being the management obligations as opposed to the obligations relating to the order in which you develop the site, because that would be a nonsense. But it must relate to that clause 5 of the 106 agreement. We can skip through the rest of it pretty briefly, but I am going to quickly draw your attention to page 136. That is the mechanism by which the costs that my client incurs in respect of the obligations it has are recovered. And at 1.3, you can see compliance with the requirements of the Section 106 agreement, and in particular in relation to the chapel. and at 1.4 in the performance and observance of the covenants on the part of the company contained in this transfer. So anything it does as an obligation under this document, it can recover as part of the maintenance contribution. It sets out the mechanism for that, and we're not concerned with the mechanism here. We're concerned with the principle of can the cost be recovered from the leasehold owners. So to an extent, I say that's all we need to consider, that's all we need to look at. What I haven't done, and it's the last document, is take you to the lease, because I say the lease is irrelevant. But I think whilst we're working our way through the documents, I probably should just finish doing the legwork and get us to the last document.
Yes.
I'm on page 65. So I'm working my way through this with the obvious caveat. But it doesn't contain any surprises, because it broadly mirrors the freehold transfer. So we have as a party the leasehold management company, a party to these proceedings, but they have the same directors as, or two of the same directors as my client. The estate management company, the appellant, tenant and landlord. The estate, this is at 1.2, you can see is the area edged light blue. You'll recall we saw those two estate plans for the two halves of the school. So depending on which flat it is, you might have a different definition of estate. Over the page, 1.8, we see reference to the service charge. This be a leasehold property. We're not talking about rent charges, we're talking about service charges, but no distinction for present purposes. So the service charge is the usual tenant's proportion of the expenditure. And then we have something called the maintenance contribution. That's the sum payable to the appellant. That's an estate charge, if we put it that way. The definition of tenant's proportion mirrors what we saw before. You've got firstly, if it just relates to the estate, a floor area basis relating to the total floor area of the let parts of the estate. If it relates to the development, then square footage of all the properties on the development from time to time.
Yeah.
And then secondly, an equal proportion. So again, it's the 1/85th again. Definitions on page 67 really mirror the freehold transfer. Communal areas is essentially the same. Development is the same. Communal facilities, communal services, materially identical. Retained parts over on page 68. Again, it's the same very wide contribution. Those parts of the development, including the estate, not included nor intended to be included in this demise or demise of any other part of the development by a lease, nor included nor intended to be included in a transfer of a residential unit on the development. So it's the same definition, just reversed to reflect its lease. This is a lease and the other's a freehold transfer. It won't surprise you to learn the leasehold management company is responsible for maintenance of the retained parts. Same as the freehold management company was, they're both liable to do the same thing. And it's not just the estate, which is that half of the school, it's the development. We have some recitals on page 69. At 4.4 and 4.5 we have, again, mirrored provisions as to the reason the management company and the company are joined in. At 4.5 the company has agreed to join this lease with responsibility for the services, so on and so forth, of the development, communal areas, the communal facilities, blah, 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 and with regard to the performance of the obligations contained in the Section 106 agreement. Bottom of page 69 I'm on. I'm going to whiz through to page 71. This is the tenant's covenant to pay the service charge. You can see it. 7.1a to pay to the leasehold management company the service charge, at 7.1b to pay contributions to my client. Nothing unexpected. We can skip to page 77. this is the obligation by the leasehold management company. At 8.2, to keep in good and substantial repair the retained parts. This is my point about the overlap. (8.6a) and 8.8, again you'll notice they're familiar provisions. Keeping the grounds and the retained parts, that overlaps with communal areas, communal facilities that my client's responsible for. At 8.8, original features and the retained parts. Again, we appear to have 3 parties liable. At 8.11, to comply with conditions of the 106 agreement in respect of the development, so far as they relate to retained parts. Again, we've got 3 parties liable on the Section 106 agreement. And on page 81, we've got the covenants on the part of the appellant under the lease. And again, it's a mirror. 9.2, to repair the communal facilities and communal areas. Again, I say communal areas. Covers the school building, exterior and structure. 9.3, again, similar point, the original feature. And then at 9.4a, to protect and maintain the chapel. And at C, to manage the communal areas in accordance with the requirements of the Section 106 agreement and to comply generally with the obligations of the Section 106 agreement. So the leasehold management company, the freehold management company, and the estate management company are all complying, are all covenanting.
So you say, if which you dispute, we can look at the lease. There's no surprises there. There's nothing to be seen because it's on all fours with the terms of the freehold transfers.
Yeah,
it's part of it's absolutely no surprise because it's a crafted part of the jigsaw that fits in with them. Is that right? Or?
It's surprising that you have that degree of overlap. And the only reason it wouldn't be surprising is if, having read the freehold transfer, you reach the conclusion, well, there's quite a lot of overlap there, that's odd. I wonder if that's what it says in the lease. I mean, I don't know that we can say it doesn't contain it. It doesn't contain any surprises with the benefit of hindsight.
Right.
But actually what you're doing is just adding another layer of parties with overlapping responsibilities. So I don't know, it goes as far as your lordship suggests that it's just sort of wholly unsurprising. It's curious that you don't have a better
demarcation.
Yeah. The other thing you don't know without reading the lease is how the costs are apportioned with respect to the leasehold properties. It could be a completely different scheme. You don't know that unless you read the lease. All you know as a freehold owner is you're going to have to pay.
You know what you've got.
You know what you've got to pay, assuming you know how many flats ultimately get built. But you know it's going to be a per unit basis. Yeah. And that often happens. Estates develop and then another few units get built and your fraction changes slightly.
Yes.
That's not uncommon.
Well, on that basis, the more
the merrier. Yes, quite. We're nearly there with all the documents. Now, page 87 is the definition of the flat. The only point for present purposes is to look at the words "but exclude" towards the bottom.
All parts of the roof and foundations.
An obvious point, but for the avoidance of doubt, and I'm skipping to page 91. That's where you get the definition of maintenance contribution expenditure, which is the money payable to the appellant, and it includes at 1.3 compliance with the requirements of the Section 106 agreement, amongst other things. But unsurprisingly, if the estate management company is liable to provide the service, the leaseholders are liable to pay it, and just the way as the freeholders are. What is relevant is 1.7 at the top of page 92 is a factual that they can add extra services, but that's not really relevant for present purposes because we're concerned with what the freehold transfer says rather than that. I think the last bit I'm going to draw to your attention is page 93, paragraph 5.3, because this is relevant to one of the points that my friend makes against me. And this is that the tenant's proportion can be varied. The tenant's proportion is the proportion that the leaseholders pay, not only of what the leasehold management company incurs, but also what the estate management company incurs. So it is in theory open to the landlord to vary the proportion so that instead of the leaseholders each paying 1/85th, they pay a different proportion. Won't make any difference what the freeholders are paying, no. But the apportionment as between the leaseholders could be varied. Now that contractual ability to vary it is subject to, because this is residential property, the jurisdiction of the tribunal, and in fact that ability to vary it would need to be endorsed, or effectively the decision would be made about it by the tribunal, and that's pursuant to various cases, but most recently Aviva and Williams, the decision of this court early 2021 that I argued. I can't remember the exact citation, but there's no dispute about it. It relates to section 27A6.
But that is a side issue for us.
It's a side issue. It survives, but it's the tribunal that would vary and not the landlord. Yes. My point is you can vary it. So if it's said, well, it's a curiosity that the leaseholders might have to pay different amounts based on who does the works, my principal answer to that is to say that's baked into this, because it happens with all sorts of different services, that it depends who does the works as to what proportion you pay. But secondly, in any event, if it's perceived to be unfair because all the works relate to one half of the school but do not the other, you could vary the proportion if it was a significant project. Well, that's all I propose to take you to in the documents. Really, all I want to do is sort of sweep up where that takes me on ground two, and then just quickly deal with the discretion points. I'm there.
Well, on ground three, it's a matter for you, but it's in fact for Ms. Matson to make her case on that, and you to reply. But if you want to deal with it first, I don't think we'll stop you. But that's really the fairness of the process, is for her to go first on that.
Well, I'm perfectly content to do it in whichever order suits. The construction of the freehold transfer is what we're concerned with. We've worked our way through it. The foundation, in my submission, for Judge Crawson's decision is a desire to avoid a conclusion that there was overlapping responsibility. And in my submission, the overriding objective of the parties, or the developer here, is highly likely to have been to ensure that, come what may, the terms of the Section 106 agreement, the planning obligations were met.
But that doesn't fit in with our task of interpretation. That's just a comment, is it, Mr. Asplin?
Well, it's the conclusion one draws from the relevant background, because we know what the 106 agreement is, and that 106 agreement binds the freehold owner and the developer. It does not bind the leaseholders, doesn't bind the management companies. If they fail in their obligations, it falls back to the freehold owner. It's the freehold land that's
and so, as a result of the Section 106 agreement and its provisions, you would say that the owner and the developer therefore want to make sure, come hell or high water, that these obligations are met.
Well, give them the best chance, yes. Yeah. One has to wonder, what is the sense in having these overlapping responsibilities? We may not need to come to a conclusion about it. I mean, we've got to read it in an objective sense. But the point I'm making is one can't say it's an obvious mistake. There's too many examples of overlaps. We'd have to completely rewrite the agreement to avoid an overlapping responsibility. And it's not that there's a lack of commercial sense in the way it's been done, because from the position of the developer, its owner is looking after listed property and having plenty of people on the hook, including all the freehold owners and the management companies, is no bad thing. So the reasoning that rests on the desire to avoid an overlap of responsibility and the influence of the terms of the lease, which is, I'm now in my skeleton argument at paragraph 23, core bundle, page 31. To the extent the judge's reasoning, and I say its influence to a considerable extent, turns on his reading of the lease, I say that can't stand if I succeed on round one, of course. And that's the point I make at paragraph 23. I'm not going to repeat it all now. And if I can highlight paragraph 26 of my skeleton argument, we do make the point that there's no rectification claim here. So the judge's desire to read it in a way that made the best sense.
That wasn't his role.
That wasn't his role. Yeah. We've got to give effect to the words used. They're complex documents. They're drafted by lawyers. So there's two parts to the declaration that was sought in this claim. Firstly, is there a right for the appellant to maintain the structure and exterior of the school buildings? Not a sole right. We're not seeking a declaration that we're the only party. Secondly, can we recover the cost of that from the freehold owners? There is a point made in my learned friend's skeleton argument. Well, actually, initially, this is in the details of claim. Initially, there was also a declaration sought in respect to the liability of the leasehold owners, and that was withdrawn at trial. I don't know the full circumstances because I wasn't trial counsel. But what one can say without a shadow of doubt is that the details of claim make clear we're concerned with the construction of the freehold transfers, and that has nothing to do with the liability of the leaseholders. That's to do with construction of the lease. We're here concerned with the liability of the freehold owners. I, of course, accept there's an overlap. If we incur cost, we have to get it from both halves if we're going to be fully reimbursed, because we can't vary the proportion paid by the freehold owners. But as you've seen in the lease, there's different ways in which that might be apportioned, and there's different considerations. And if it turned out on the wording of the lease we can't recover our costs, that doesn't change whether we can recover against the freeholders. Paragraph 29 in my skeleton argument onwards really set out my submissions on the first part of the declaration. And I've taken you now through the terms of the freehold transfer. I'm going to be repeating myself, and I'm not going to do that, to run through it again. I say, as you've seen, we covenant to comply with the obligations in the Section 106 agreement generally, and in certain specific respects, especially the chapel, and there are the communal area covenants. And I say that, read together with the Section 106 agreement, which clearly contemplates it would be a management company, the company that gets the £100,000 chapel contribution that is liable for the upkeep of the listed buildings, and the school is a listed building.
So you've come to comply with the Section 106 agreement generally and specifically, plus the definition of communal areas.
Yes. And we take into account the Section 106 agreement that contemplates a single management company responsible for the upkeep of the listed buildings, whose members are all of the owners of the dwellings, leaseholders and freeholders. And it is the stated purpose in the transfers of the appellant being a party to them that the obligations in the 106 agreement are kept to. It's only the company that can recover costs from both sides. It's all very well the freehold company covenanting to maintain the retained parts, but how does it recover the cost from the leaseholders? And the leasehold management company has the same problem. And really, it comes back to once we accept that you can't avoid overlapping responsibility, you're left free to construe the words as the parties have used and give them their ordinary meaning. It's only when you try and avoid that overlap of responsibility that you come to a different conclusion. And there might be good sense to that, but there's too many examples to be able to do it.
In terms of the obligations under the 106 agreement, it says, looking at Part 3, Paragraph 5, which you quoted in your skeleton, Section 29, verse number 1, is to ensure, that's the word, performance of the obligations. Does that indicate ensure that someone else does it, or does it mean will carry out the obligations?
It is, it's ambiguous in that respect. I think the key point to make on that is that's in a recital in terms of saying why you're a party.
What you're doing, yes.
We need to look at the operative provisions to work out what the actual answer is.
Right, okay.
The way Judge Crawson rationalised it, one can well see why, was to say, well, you might have a residual role to play in the background, but that's just one where you'll step in if nobody else does anything.
Yes.
That's the point that's taken against me. That's one. One can see the reason for that when one considers the wording to ensure the performance of, but that's not the operative provision. That's relevant background. It's part of the recital. I think if one look, my answer to it is say, well, if we look at all of the relevant provisions and including the intended purpose and the 106 agreement and having a single management company responsible for the listed buildings.
When we look at what the company covenants, which is your number 2 in this list, paragraph 29, it's part 12, paragraph 6.
Yes.
And the point that is part of what turns here is the definition of communal areas and communal facilities. You say that this is a covenant to maintain and manage the communal areas, which includes the fabric of Mostyn House School building.
Well, Lord, yes, but also it provides that we must comply generally with the Section 106 agreement. I don't say it there, but if you go to the provision in the transfer, it's the provisions with respect to communal areas, but it's also to comply generally with the Section 106 agreement.
Well, with the obligations detailed in that agreement.
Yes. Yes, to comply generally with the obligations, as the lady says.
And it's the point my lord made, whether in fact the obligations are those of the company or someone else.
If we other than me guessing, it's page 128, I think, is what we're looking at.
Yes, that's what I think.
Yeah, to comply generally with the obligations detailed in the Section 106 agreement. And that is contrasted with the wording in the recitals on page 112, which refer to ensuring the obligations are performed. But the recital is not the operative provision, it's giving us evidence of what the parties considered would be relevant background information when you construe the document. That's the purpose of the recital. At least that's the purpose we can take from the recital.
But in terms of your case, and you quite rightly, I'm not criticising it all, took us to a whole range of provisions. It really focuses in on this part 12, paragraph 6. That's what you're obliged to do, you say, and when you say that requires you to do this.
Yes.
And so therefore,
I have the add-on
for your declaration, you're certainly entitled to do it.
Yes.
Which is what you're seeking.
That's all we're seeking. Yes.
Not exclusively entitled, but you're one of the people who is entitled, one of the agencies who are entitled to do this.
Yes. My friend's about to stand up and explain why I'm wrong, so I'm not going to preempts all of her points. I'll wait until afterwards. But the Jarrah House point, I've taken you through my answer broadly to that. We don't need...
This is not at all easy. And,
No.
A cavalier thought has gone through my mind that those who drafted these provisions ought to be made to watch the YouTube clip of this film, all suffering as we try to work out what on earth was meant. But that would be cruel, I think.
Wow.
But Mr. Allison, if you could therefore just, I know you've been through it, but in relation to Jarrah House, in just a few sentences, your position is?
Number one, duplication responsibility is baked in. So the fact that the freehold owner of Jarrah House is responsible for it, and the freehold management company has step-in rights that we don't have, in the sense that they can jump in and do the works and directly recharge. It's just seemingly part of the scheme. It doesn't change the fact that the estate management company, if it's going to comply with the 106 obligations, can do works to Jarrah House and recharge the cost on a 1/85th basis. It wouldn't do it unless the freehold owner had failed to maintain it. I mean, you can't put something into repair unless it's out of repair. But it's entitled to do it, and that's all we seek is that.
Yes.
So yeah, duplication responsibility, we don't need the step-in rights. The second part of the declaration is whether we can recover the cost. That, I suspect, is less contentious. I've taken you through the provisions. If we incur the cost, we can recover the cost. In a leasehold context, that will be subject to them being reasonably incurred and the statutory control the tribunal exercises over it. That doesn't apply to the freehold side. They might say we haven't properly incurred the cost and there's an implied term or whatever. You can have arguments about it, but what we're seeking to establish is the principle. We're not saying we can do highly extravagant works that go above and beyond what our obligations are and recover the cost. It's not seeking to constrain any future argument as to the quality of the works. It's a point of principle. But in my submission, it's quite obviously recoverable. It's under Part 2 of Part 15. It's on page 136 in the supplementary bundle. We were looking at it earlier, the mechanism. Yeah. I entirely accept that there will be different consequences as to who is liable to contribute based on which of the parties do the works. And my own friend says, I might be wrong, but my recollection is she says in Escalating argument that's absurd. It might be.
Well, she said it can't be right that it turns on who gets in first.
Yes.
That's one of the phrases used.
Well, maybe I made up the absurd. I thought I read it. Maybe I thought it was absurd.
Was it?
There is, yes, there is
There we
reference to absurd. But it's an unavoidable consequence. Because we're not just concerned with the school building as an overlap of responsibility, there's all the other areas. So that's what the parties are to be taken to have meant. Rightly or wrongly. And you'll see at paragraph 86 of the judgment, Judge Crawson says he doesn't consider that transfers and leases provide for two parallel repair regimes with fundamentally different consequences to who is to contribute. And that just can't be right. Page 117.
Thank you very much.
So you're looking for it.
So which paragraph?
Paragraph 86.
Yes, no, I'd mark that. Yes.
So really, those are my submissions on those two grounds.
Well, that's been an extremely helpful exercise, certainly so far as I'm concerned. Anything else you want to? No. Thank you, Mr.
Well,
Allison.
I'll leave the declaration point you've heard in my opening.
I think that's
broadly where I am.
That's the fairer way to do it, and then we'll hear you in full if we need to, of course. Yes, Ms. Matson.
My Lord Lee, forgive me, may I ask for a 2-minute comfort break before I
Yes.
commence?
Yes, and then it's too early to think that we'll break for lunch now, but so far as ground one is concerned, you you might be able to conclude that before the lunch.
Yes, I do hope so.
Yes.
Yes.
So we'll rise for a short time.
Thank you so much. Yeah. You can't.
We were waiting for a message that you were all comfortable, but we assumed after the passage of time that that was the case. Good.
Thank you so much, my lord and my lady, for a few minutes. Now, before starting on round one, I want to make some high-level points about my client's case. As set out in the judgment, it is not my case, and nor what the judge is finding, but there are no circumstances at all in which the appellant could step in for compliance with the 106 agreement. My learned friend and I both agree that we can see a belt and braces approach here by the developer to ensure compliance with the 106 agreement. Where we differ is whether or not there's a hierarchy of those obligations. And I say on the true construction of the transfers, but also the leases, it is clear that there's a hierarchy of obligations, primary obligations and their fallback obligations. It is against that background that I say that the appellant is not entitled to an unconditional declaration that it is entitled to go into the school buildings and undertake works when there is no evidence, nor contended that there's any breach of the 106 agreement, that there's any disrepair. I say what is not permissible is this unconditionality where the appellant takes it on itself to undertake his works when there are other companies with primary obligations on the true construction of the transfer and also the leases, which feed back into my third point, which is why it is so inappropriate to seek a declaration on the terms which are being sought against the background of carefully calibrated, I say, obligations and liabilities within the state, where when one takes a step back, I'll take you through the provisions, which I say show this, the intention in my submission is clear. It is intended that the freehold owners should pay more for their part. The leasehold owners will pay more for their part, and particularly when we're looking at the estate and the leasehold owners' obligations with respect to their own buildings, the intention is that they pay for their own building. There's no overlap there between the two separate school buildings. But that goes into the discretion point, which is, of course, what I call ground 3. So those are the high-level points as to why I say this appeal should fail. Then, addressing ground 1, whether the judge was correct. Well, I say he was correct on 2 matters. One is as set out in paragraph 71 of his judgment, page 112 of the core bundle, which is that actually nothing turned upon whether or not these leases are admissible and considered as part of the construction of the transfer. The point is rather academic. It's not something that we spent a lot of time on on the first trial. But I also say that the judge was correct for the reasons that he gave at paragraph 65 to 71 of his judgment to take into account leases when considering the transfer. Now, I say he's right by just referring to what we can see in the transfer itself to address it in the 2 stages that my learned friend addressed it, which is first without reference to share tree and then with reference to share tree. Now, as found by the judge, we have, and we looked at this paragraph 25 of the judgment at page 90 of the core bundle, my learned friend, the judge found that the freehold and the leaseholds were sold off contemporaneously. I accept the point my learned friend makes, which is that yes, the freeholds appears to be sold off, some of them before, and there was a good reason for that, but the factual finding is they were sold off contemporaneously. There isn't an appeal against that. I accept that we can see from the official copy entries of the freehold title, and for your reference, they start behind tab 9, page 141, which is Gray's freehold, and we can see at page 147 that the first lease was only registered on the 5th of November 2014.
So that's page 147 of the supplementary bundle.
That's correct. And that's just an extract from the official copy entry on the freehold, where we can see the date of the leases and the registration of the leases. So I accept that point.
So the first lease is October 2014.
That's correct. It's the second entry of the schedule of notice of leases. 16th of November is what we can see the date of the first lease, and we can see the date of registration on the first column on the left, which is the 5th of November 2014.
Yeah.
No. So I don't dispute the factual point being made, but I say it doesn't detract from the factual finding made by the judge, which is that here we were looking at the development contemporaneous sale of leaseholds and freeholds. I also do accept that these transfers cannot change. So we need to look at what was first in time. That, in my submission, it is plainly correct. Now, but when we look at the transfers, can it be said that they...
So just to catch up on the point you just made, so are you accepting or not accepting that no leases existed at the time that the freehold transfers were made?
I accept that it appears on the evidence that there were no executed leases. No leases have been entered into.
Yeah.
But as we will see, the judge has found is that there would have been leases in identical forms pursuant to the 106 agreement.
And you say there's no appeal against that finding.
Correct.
And so we have to accept that as the finding and use it as part of the basis for our exercise.
Indeed.
Yeah.
When we are looking at the factual findings that were made at page 111 of the core bundle, which are the subparagraph little 1 of paragraph 70 of the judgment, I say that the judge was plainly entitled, based upon the findings that he made, which are not challenged, that it is more likely than not that it would have been reasonable to assume the test is what background knowledge would have reasonably been available to the parties. It's not a question of whether you had it or not. I said the question is whether or not it would have been reasonable available to the parties. And against that, so I say that looking at the findings that we have at page 111 and paragraph 70, and then looking at the transfers itself, the judge was entitled to make the finding that the leases would have been available to a reasonably diligent conveyancing solicitor. Now, I want to start taking you through the transfers themselves, because in my submission, they make it clear on the face of these documents that they are leases which are relevant, and you cannot understand these transfers and the obligations therein without reference to these leases and understanding what is happening on the rest of the development. If I can start by taking you to the retained part, which we looked at with my young friend, which is page 110. What we can see is that the definition of retained part, which we don't have...
Just a moment. So we're at page 110 of the supplemental bundle, and so we're in the transfer.
We're indeed. So I'll take you through the transfers and the provisions therein, which I say themselves make it clear that the leases would have been asked for or would have been available to a reasonable, diligent conveyancing solicitor, and that the judge was right to make that finding based upon what is in the transfer itself. So if we look at the retained part, we can see that it relates to the development, which has not been sold off by the transfers, nor intended or included in any demise by a lease of a residential unit on the development. Now, as the judge in my submission correctly found, is that it is not possible to understand what is intended by retained part without reference to the leases. Now, one can make assumptions, of course, and the judge made that clear in his decision, that it may also be that on the standard conveyancing practice, this is little 2b at page 111, it is perhaps reasonable to assume that the structure and the exterior of a school buildings would have been excluded from any demise and therefore would have fallen into the retained part. But I say the fact that you would need to make assumptions, you wouldn't be able to know, and there are various obligations and payment obligations attached to what is the retained part, make it very reasonable that any conveyancing solicitor would have required sight of that lease as part of any transfer, because they wouldn't have been able to advise their client fully on the transfer without that reference. Now, there are other references to leases in the document itself, in particular.
Sorry, and what do you say about Mr. Allison's point that what if it gets sold on by the freehold purchaser almost immediately? That's a different situation, and that purchaser, that further purchaser, wouldn't have access to the model lease or whatever.
Well, there is always the possibility that, and I think my learned friend made the example, what if someone refuses the request? Well, that argument would then be consistent with what if someone refuses access to have a look at features on the ground for the purposes of inspecting boundaries, which we all accept. The features on the ground are part of the construction of what forms part, for example, of a transfer or demise. So the question is not whether or not they had access or whether they could be denied access. There's always a possibility. But I've said the question is what would have been reasonably available. And when a transfer cannot be properly construed without reference to different documents, the analogy there is when you have a head lease, for example. Very often you will have a catch-all in a lease to comply with any head lease. Now, you would then require sight of the head lease in order to fully understand the obligations of the lessee in the sublease. I say this is analogous. Here, when you can't fully appreciate the obligations, particularly if they pertain to a school building, which is a listed building, without having sight of what has been retained as part of those transfers. And we know there's a large development which is being undertaken at the same time. We come to the 106 agreement that we again have to find in respect of. Taking all those matters into account, I said the judge was not wrong to find that it is more likely than not that these leases would have been available.
But dealing with the point of someone who's party to the original agreement selling their freehold plot on the following day to someone who's not party and can't get access to this, on one view that doesn't matter because we're construing the words used by the people who were parties to the original agreement. And your case is that those were in a position, you say, and the judge found, with reasonable diligence, to look at a draft lease.
That is right. I think that point, however, of course, because the meaning of the words in these transfers cannot change depending on who's buying and selling. I accept that there is a point about what is reasonably available to purchasers. Now, I think taking a step back and considering reasonably available, again, and I guess I come full circle to even if there had been a subsequent purchaser, the terms of these transfers would still, and we'll have a look at other examples, have been referring to leases and provisions which can only be fully understood by reference to other documents. So in my submission, I guess it doesn't quite matter whether or not you got subsequent purchases or not, because that reasonable conveyancing solicitor would be in the same position of requesting information in order to be able to advise their client as to the true meaning of this document. Now, so retained part is one example. The other example where we can see express references to the existence of leases is at page 117. Paragraph 2, part 8. again, if we look at the last two lines of paragraph 2, we can see the covenants by the transferee with the transferor, and it relates to the obligation in respect of joining.
Which words are you reading?
So again, we see the last 3 lines is talking about, or the last 4 lines, that once the development has completed, then the transferee covenants with the transferor that if so required, then to join with other properties in the development, so that would be the freeholders, and of course we know leasehold.
I can't see these words that you're using. Where are they on page
Page
117?
117, part 8, paragraph 2, my lord.
Yeah.
So once all properties on development have been sold by the transferor,
Right. Okay. I'm there.
if and when so required by the transferor.
So I thought you were at the end of that paragraph.
Yes, sorry, I jumped without explaining what this provision relates to. Forgive me, jumping ahead. Then to acquire in the name of the management company transfers interest in development for a nominal consideration of £1 plus the transferor's legal costs. But we can see that this relates to the development, and again they express reference to the obligations under this transfer and leases in the development. So we can see on the face of the transfer itself that it anticipates the existence of leases in respect of other part of this development. Now, I accept my friend's point, which is it's not identified exactly what lease this is. It's not a defined term, but in my submission again, the judge was correct to say that against the clear wording on the face of these documents that there are leases in existence in respect to this development, or at least intended to be, that it would have been reasonable to assume that the diligence conveyancing solicitor would have had access to them, or would have had reasonable access to them, if necessary.
Does that follow? This is not my field, but if you've got a building like Mostyn House School and you're going to convert it into separate apartments, would they have to be leasehold apartments? You couldn't have freehold apartments in that building.
It would be highly unusual. You
So-
can have flying freeholds.
So the fact that if you're sitting down drafting this document for the freehold transfers first, because you've got to do that first to get the money to do the work on the schoolhouse itself, everybody would have known, if this is right, that there would have been leases, because that's what there would have to be.
Yes.
And so doesn't this simply tell us that everybody knew there'd have to be leases, so there's a reference to
Yes,
leases.
and
It doesn't mean as night follows day that there would be a draft lease available for a diligent conveyancer to find.
so that we then take from the 106 agreement, which is the follow-up of the factual findings. So the factual findings made by the judge are set out at page 111. You have a numerous of those facts, and they combined in my submission makes up his finding that it is more reasonable than it is more likely than not that leases would have been available.
But did the judge rely on, you've taken us now to two, I understand we've taken these two at page 110 and page 117, references to the two words, the leases.
So
Did the judge rely on those?
the judge did not rely on paragraph 2. I did take him there.
Mm.
He relied on the definition of retained part in respect to the leases. The other part is the reference to page 139, which is again just reference to a deed and tenants and incoming tenants. Again, in my submission, making it clear that anyone reading this transfer would have known that there were leases contemplated. In my submission, the question of retained part makes the point most potently. It is the best point that I had that he has taken into little 2b in his judgment. Now, the judge then goes on to find that one, and I say correctly, when you are looking at the transferee's proportion, again, you wouldn't be able to appreciate and understand the liabilities of the purchaser of this freehold without considering what the liabilities were in respect of the remainder of the development as opposed to the estates. Now, the judge then found, of course, that we had as part of the background, which was common ground below, and of course common ground in this court, that we had the Section 106 agreement as admissible background. When we look at the wording of that Section 106 agreement, and 50A of the supplemental bundle, and it's paragraph 5.5.4, the judge found that, again, as part of the factual background, it would have been known that the obligation was to sell off these dwellings on a standard form of transfer or lease will be used in the sale of each dwelling, so that all transfer leases contain identical provisions in all material respects. And this is his finding at little d of the judgment. Now further, the judge placed reliance upon the covenants in the transfer, which are enforceable. This again goes back to what a reasonable diligent conveyancing solicitor would have done when they had seen these covenants. You would have wanted to know who was going to be able to enforce covenants against your clients. So the restricted covenants in the transfer, page 118,
Thank you.
part 9, we can see, and we have this reflected also in the leases that we look at that in due course, is that the transferee, with the intent to bind a property, and any person who from time to time being the owner of the estate or interest in or the occupied property or any part, covenants with the transfer law, and as a separate covenant with the management company, and further as a separate covenant with each of the owners for the time being of the other properties under development. These are the covenantees. So what Part 9 does is that it provides that under Section 56 of the Law Property Act 1925, these restricted covenants are not just enforceable by the company or the freehold owner or the management company, but also by all the lessees, because they are owners on other parts of the development. It is not their estate. So it's not just the freehold owners who can enforce these restricted covenants, it's anyone in the development. And this is another part that we see in little c that the judge kept firmly in mind when considering what would have been available to a conveyancer when you are faced with these covenants in your transfers, which can only fully be understood and advised upon when you have the benefit of, I say, the leases of the rest of the estate, the rest of the development. So when the judge goes on in little 3 at page 111 to find that there's a clear link on the face of the transfers between the leases and the transfers, and that he can have regard to the fact, this is over the page 112, that the leases would therefore be background knowledge which would have been available to the parties, including the transferees, because you wouldn't have been able to understand these transfers without it. I say that the judge is entitled, based upon those documents alone, and what is on the transfers themselves, to find that it is more likely than not that it would have been reasonably available to the parties that these leases and their terms thereof.
Now,
What we're not looking at is the question of what was available, and that the judge didn't need evidence of, for example, a sales pack as referred to by my learned friend. That is not the question. The question is reasonably available. We find that at Cherry Tree,
right. But if we're going to move on to Cherry Tree, let's
Yes,
pause there
of course.
and resume at 2:05, if that's convenient to everybody. Thank you. You will rise.